welcome to everybody, and thank you for joining us today. The Selkie Project is organising a series of events focused on providing business support for companies looking to diversify into the marine energy sector. These events will give your company the opportunity to learn more about key themes from experts in the sector to help in your endeavours to enter and work in this innovative and growing industry. It will also give you the opportunity to network and meet with other companies. So this session today will be focused on legal matters in offshore energy, and we're delighted to be joined by our experts today, Tom Adams and Kathleen Doyle from Stephenson Harwood. Tom Adams is a marine and energy specialist with particular expertise in dispute resolution and negotiating contracts relating to offshore construction, decommissioning, shipbuilding, and projects involving offshore units. Tom frequently presents for BIMCO on their offshore suite of contracts. Kathleen Doyle is an international dispute resolution lawyer, also specializing in marine and offshore energy. Cathal advises clients on disputes in the English courts and international arbitration. Cathal also frequently assists clients on non-contentious matters in relation to negotiating and drafting contractual documentation. So Stephenson Harwood is a law firm headquartered in London with over 1,100 people, 10 offices worldwide, and their work includes shipping and offshore energy practices. In maritime, Stephenson Harwood acts for the owners or charterers in vessel building, insurance, financing, chartering, offshore construction, and transportation projects. In energy, Stephenson Harwood has been engaged on several offshore wind farms, tidal, hydrogen, oil and gas, and hydro projects in providing corporate, finance, commercial, and dispute resolution assistance. This session today will discuss what different standards of performance the parties to a contract could be held to depending on the wording of the contract, and the important things to include or avoid in your contract depending on whether you are the employer, contractor, subcontractor, owner, or charterer. In particular, we will look at some real cases in these areas of design risk, fitness for purpose, obligations as to time, and time of the essence. So before I hand over to our speakers today, I'm just going to run over a few bits of housekeeping and some guidelines. If I could ask that everybody remains on mute unless you have a specific question for our speakers today. This just stops any feedback and ensures that everybody can hear our speakers clearly. If you could all please also include your company name in your Zoom name. You can right click on yourself and add it there. That way we know where you're joining us from. So the plan was to have the presentation and then a Q&A afterwards, but our speakers have informed me that they're happy to take questions throughout their presentation. So if at any point you have a question, feel free to either submit it in the chat or use the raise hand feature, and then we will come to you. And then if you need any assistance at any point, feel free to send a message in the chat. We have the Selkie team on hand to help with any technical difficulties. And also please follow us and mention @Selkie Project, #Meet the Expert on social media. This session will also be recorded and it will be shared on our website in the coming days. So now to just give a very quick overview presentation of what the Selkie Project is for those of you that are perhaps a little bit unfamiliar with our work. Let me just see if I can find this now. Am I in presenter mode again, Manon?
Yes, yeah.
1 second.
There we go.
You should all now be able to see that. Thank you.
Yeah.
So the Selkie Project is a collaborative project between 6 main organisations. They are University College Cork in Ireland, Swansea University in Wales, Marine Energy Wales, Mentor Morn from Anglesey, DP Energy, the Irish energy project company, and Gavin and Doherty Geosolutions, a Irish consultancy working in a range of energy and geotechnical areas. So these 4 organizations, we come together and work together with the aim of streamlining and bringing down costs in the wave and tidal industry. We do a lot of work to bridge both industry and academia. As I said, with the aims of bringing these costs down. We try and make sure that research is purposed for the benefit of industry and that industry feeds into this research as well. So as part of the project, a number of open source and open access tools are being developed by academia for the benefit of industry to help bring down costs and make things easier for those that are working in the sector. Alongside that, we also do a lot of industry engagement and we're creating a business support network. That's part of what today's event here is all about. We're here to provide information, knowledge sharing, networking, all to help those that want to work in the wave and tidal industry access it more easily and bring down costs and the barrier of entry. You can sign up to the Selkie network to receive all the news and information on what we're up to gain access to future presentations such as these if you're not involved already. So on screen we have an example of some of the companies that are in the network already. And down at the bottom, we've got some of our links if you want to reach out and find out a bit more about the Selkie project. So there's our website there, selkie-project.eu. We're on Twitter at /the Selkie Project, and also on LinkedIn as well. So please reach out if you'd like to continue a conversation with us. So I am going to stop sharing and hand over to today's speakers.
Thanks very much, Jay. So hopefully, once this loads, you'll all be able to see what we're looking at here in London. And I'm just going to swap.
Yeah, we have that.
Perfect. Good morning, everyone, and thank you, Jay, for giving myself and Tom Adams an opportunity to speak with you all today. As Jay said, my name is Cathal Lee Doyle, and unfortunately, unless you are Irish or come across the name before, it's a name that just travels extremely badly internationally. But the best way I've learned to explain it is saying alcohol and taking away the first al, if that makes it any easier. But we're delighted to be here speaking with you all today. And Tom and I completely appreciate that a law lecture at any time during the week is not anyone's priority, so I appreciate everyone dialing in today. But given the sector we're working in, even the low value projects are extremely complicated, and the fact that the contracting service is a competitive process. So the more comfortable you can become with contracting and the principles behind some of the clauses that are in the contracts that you will come across, it can seriously benefit you and the company on a short-term basis and a long-term basis. The principles that we're going to go through today will be applicable to any company at any stage in the life cycle, and whether you're entering into a 2-page contract or a 900-page EPC multi-billion-pound waiver title contract. And essentially the approach we're looking at from the offshore energy side is the what and the where in every project. Appreciating that everyone has been zoomed out for the last 18 or 19 months, as Jay said, please do engage as much and as frequently as you'd like. We're more than happy to answer questions or even discuss issues as we go, rather than saving them up to the end just in case we run out of time. As Jay said, he saved me my introduction. Tom and I both are here with Stephenson Harwood, headquartered out of London, with 9 offices worldwide, based in London, but do a lot of work across the United Kingdom. Our clients essentially cover the full spectrum of all projects. So it ranges from fabricators all the way up to tier 1 subcontractor and employers and utilities. And generally, we are instructed normally at main junctures throughout a project. So that will start in the earlier stages during negotiating high value or complicated projects, and then straight through to real-time advice during the project. And if the project encounters some hiccups, we will also come in through the dispute resolution side.
Right, hi, good morning everyone. I'm Tom, I'm one of the partners at Stephenson Harwood. So the plan for how we run through the talk is for Cathal to lead and for me to chip in as and when in a sort of more conversational type of style. What we sought to do when we were putting the talk together is consider that on the call there's quite a wide range of service providers and employers dialing in. So the legal issues which you come across and which you'll be most concerned with in your contracts may vary according to where you are in the value chain, for example. But we wanted to obviously find something to talk about which would be of most interest to most people. And common to almost every contract you'll come across is that the contractor needs to produce or provide something, a service or an item or a unit or whatever it might be. And it must do so within a given period of time. So those things, the what and the when, are common to most contracts. And so the issues that arise around those areas are the ones we're going to talk to you about. And where we end up is to encourage you to think to yourself, how do I protect myself, my company, from exposure if the risks in those areas do eventuate? If there's a problem on my project, how do I protect myself from a risk that perhaps, or a liability that could be a company breaker? And that's really the aim of this, that you come away being able to focus on where the risks might be in these areas, and with a good understanding of what sort of clauses you might want to include to protect you.
So following on from that, the issues we're going to specifically look at are design, responsibility and risk, fitness for purpose, obligations as to time, and then, as Jay said in his introduction, we'll have a Q&A and go through any issues you'd like to specifically talk. These concepts may be familiar to most of you dialing in if you've considerable experience in the contracting side of things, but these three issues essentially will come up in nearly every offshore project in one shape or form or another. So first, we're going to look at design, responsibility and risk. And essentially, this is the what of the contract. What am I doing? So as most of you will be aware, contractor is obliged to perform its scope of work. And the scope of work will be either provided by employer or negotiated between the parties, but there will be hopefully an identifiable and understandable scope of work. And the scope of work is to complete the work according to a specification. Now, this can't be underestimated, and while it's a very historical case, being 1872, it's a very vivid example of when parties to a contract, or one party to a contract, just doesn't understand the specification. And in this case, I think it explains itself, where the contractor agreed to complete a whole railway line on the basis of an engineer's specifications for a fixed price, which to everyone here today sounds completely normal and understandable. However, one term in the contract stated, the contractor will execute and provide not only all the works and materials mentioned in the specification, but also such other works and materials as in the judgment of the company's engineer-in-chief, which are necessary or reasonable implied, are to be inferred from that specification. And that's where the wording becomes a lot broader and a lot more uncertain. And in this case, what ultimately occurred is the company's engineer came on site, wasn't in agreement with contractors' design and the specification of the works that were required, and ultimately required that double of the earthworks had to be carried out along this section of the rail line. Of course, when the works had been completed, contractor approached employer looking for additional costs for undertaking the additional earthworks that were requested by company, and company refused. And this proceeded to the English court, where the judge found in favour of company, saying that contractor had agreed in their specification that if company's engineer requested additional materials and or time, that was for contractor's account. So we can't overemphasize just how important it is getting to grips with the specification and the scope of works. We then go on to cover the issue that the scope of work may or may not actually include a design element. And this will depend on what actual component you are making, be it a pre-made widget or a very standardized widget, all the way up to, let's go with an EPC contract for putting in a foundation for one of the tidal components. And realistically, what is essential to understand is that the standard of performance required in carrying out this scope of work in accordance with the specification is at the minimum standard of a reasonable contractor. And you may ask, what is a reasonable contractor? Because we all think we're reasonable at all times of the day. But from a court's perspective, when they are assessing what is a reasonable contractor, they will objectively assess how a notional reasonable contractor would have acted in the circumstances. So they will take into consideration all of the information available to the contractor at the time, and then assess whether or not that was actually reasonable. However, building on that, the contract itself may include a fitness for purpose warranty. And this is the major issue which should be, I wouldn't even use the example, a red flag for both parties because of its importance that's given to fitness for purpose. For those of you who haven't come across the term fitness for purpose, it's essentially a warranty that is an absolute obligation. And when we're talking about an absolute obligation, what we're saying is that even if you were reasonable in your skill and care in producing or providing a service or a product, that actually has to be fit for the ultimate intended purpose. So it substantially increases your obligations as a contractor, subcontractor, or supplier in providing a good or service to a company. And if this warranty is given, you're going to be held to that obligation regardless of the reason the works or the design doesn't meet its intended purpose. So essentially what we're trying to say is here, this takes the contractor or the designer beyond the duty of reasonable skill and care and impose an absolute obligation, which is an onerous obligation. And where work is not fit for purpose, the contractor finds themselves in a difficult scenario or situation because, as we say here, it's no defense for contractor to say that they carried out the work diligently and in accordance with industry standards, i.e. reasonable skill and care was used, which is normally the wording you will see in your contracts. And even if the work meets the specifications set out in the contract, the contractor has to go further than that and make sure that the work actually is fit for purpose for its intended end result.
Yeah. So just before you go on, Cal, there's quite a lot going on here. So fitness for purpose is an issue for contractors because it introduces an element of some uncertainty because there's some subjectivity here. So has the contractor been made aware of the detailed intentions of the employer with regard to this particular piece of equipment? So is it understood how it's intended to be used and its precise purpose? How fit does it need to be? What does that mean? So there is some uncertainty there, which contractor is at risk of, in essence. And then also where we refer here to this idea of industry standards as being some sort of benchmark of whether a contractor has performed its obligations. Where we're dealing with fairly new industries, new technology, that can be hard to pinpoint. What is the industry standard in an industry that hasn't developed a standard? So for a contractor seeking to rely on those sorts of concepts which aren't entirely clear or fleshed out, there's an element of risk there. And so what we're saying really is from a contractor perspective, the ideal is that you are able to say at the outset precisely what it is that you're obliged to do to have discharged your contractual obligations. And the simplest and therefore the least uncertain thing is for a contractor to be able to say, well, I just need to complete my contract in accordance with a set specification and nothing else. That's the ideal for a contractor. But often these terms find their way, terms like fitness for purpose and obligations as to that, find their way into a contract one way or another, either through express wording or where they're implied by statute. And they can mean that a contractor's obligations actually exceed what on the face of the contract and the face of the specification appears to be the contractor's obligation.
Yeah, and from an employer's perspective, they're including the fitness for purpose warranty or obligation in order to try and mitigate the risk, in order that they're putting that onto contractor in providing that the works. The other issue, which is very important from a contractor's perspective to take into consideration if you are agreeing to a contract, which has to be fit for purpose, is an insurance perspective, because from our understanding, it is very difficult to get insurance on a contract where you've agreed to provide the works and they will be fit for purpose. So it is one issue to consider, and we'll come to it later on in the presentation, but one issue to be alive to before you enter into that contract. So the scenario where we find ourselves quite frequently from dispute resolution perspectives is that, is it a defense for the contractor if, due to errors in the client provided basic design, the work is actually ultimately not fit for purpose or cannot meet the functional specification? And this is a situation which arises frequently, especially in emerging markets and sectors such as wave or tidal, because as Tom said, the industry standards aren't there. So actually knowing how the technology and the work product will conduct itself when put into service is massive uncertainty for all of the parties involved. So the contractor is taking a considerable risk, but ultimately it finds itself saying, well, it doesn't work, but you provided the basic design of my scope of work or the specification. And that's the reason why ultimately the end product is not fit for purpose or can't actually meet the specification. So a conversation could there come, and ultimately, unfortunately, the answer is it always is going to depend on the contractual wording on who's going to bear that risk. Because contractor is likely going to bear it if it has warranted in the contract that it will, for whatever reason, it will be fit for purpose and or meet that functional specification. And if the contractor has agreed to that wording, whether or not the employers or the end client's design was ultimately incorrect when it was provided to contractor is going to have to bear that risk. However, employer will bear that risk only if the contractor has agreed in its contractual terms to meet a very detailed specification, which the contractor will very easily be able to say, I have met that specification or I have not. But essentially, this issue is made more difficult because what we find is that the client rarely warrants the design. So the contractor has to make itself comfortable with any design or any information that it's being provided with from the employer.
Yeah, so what we're saying there is it depends on the contract wording, but the warning, I think, for contractors, and it's sort of highlighted in that case, which Kat summarised, is that I think the court's general approach is that where there's uncertainty, it will err on the side of seeing the contractor as the party that bears those sorts of risks to deliver something that works. So if contractor doesn't want to accept those risks, it needs to be clear in its contract that it does have only that bare obligation to meet a defined specification and nothing further.
So I thought we thought it might assist to just assess this from all of the parties' perspectives, given the wide range of members who we have on this call today. And essentially, when you are negotiating a contract, or even more importantly, pricing a contract, whether or not you're going to agree for fitness for purpose, as we've said, which is the higher standard, the more onerous standard, and can create some considerable risks for a contractor, but employer has mitigated his risk. Essentially, it's going to depend on what party you are in that negotiation. Because if you are the employer, you are going to want to mitigate your risk as much as possible. Therefore, including a fitness for purpose contractual obligation on the contractor is going to suit your objectives. Now, the other flip side of that is in the pricing. If contractor is forced to or is incentivized to accept that the work is going to be fit for purpose. You would think that that will be built into the pricing. But what we're readily aware of across the market in offshore service is that the contracting is a competitive process. Therefore, employer does not necessarily have to pay a considerable higher price for even getting fitness for purpose accepted into a contract. But from the contractor's perspective, it's absolutely critical, if you are agreeing to provide the work fit for purpose, that you are pricing that in accordingly, because as Tom has said, and as that case example sets out, there is uncertainty most times. The parties are entering into the contract at that stage, be it design risk or actually just specification uncertainty. And as Tom mentioned earlier, the major issue is that all of the information may not be even available at the time you are negotiating the price in the contract, which makes it, again, considerably riskier for contractor. And again, if you are a subcontractor or a supplier in a contract, agreeing for fitness for purpose is even one more level up of uncertainty, because as a subcontractor, you might be supplying a widget, not knowing where the widget is going to be used or how it's going to be used. So therefore, agreeing to fitness for purpose is considerably riskier than, let's say, an EPC contractor who has hopefully a lot more information available to it at that time. So ultimately, whatever party you are in the life cycle of the project or a stage of the project, it is going to dictate heavily whether or not you can accept fitness for purpose, or if you want it actually to be inserted in the contract in the first place. And this is all, well, very well explained by this very famous case, and most of you, or some of you, may have come across this from a contracting perspective, because it's received considerable attention across all of the construction industry, onshore and offshore. And this is MT Hoggard versus E.ON. And as you can see on the left, MTH, which was the contractor, agreed to design, fabricate, and install 62 monopile foundations for an offshore wind farm. The foundations were installed in early 2019. However, within a number of weeks, it became identifiable that the foundations were already failing. The parties to the wind farm agreed to undertake remedial works immediately, as the faults were only going to increase in magnitude. So the remedial works were undertaken immediately at a mutually agreed cost of just over 26 million, which is a considerable sum by anyone's assessment. And then ultimately the parties had to confirm or to decide who should pay for this 26 million. And apologies for breaching PowerPoint 101's rule, which is never more than 20 words in a slide, but it's important to just go through the relevant clause wordings here. So the applicable clauses, which ultimately the dispute came to decide, is the contractor shall, in accordance with this agreement, design, manufacture, test, deliver, and install and complete the works, so that each item of plant and the works as a whole shall be free from defective workmanship and materials and fit for its purpose as determined in accordance with the specification using good industry practice. So as you can see in clause 8.1x, they've expressly stated that the works have to be, or the plant, which is the term used in this contract, the plant has to be fit for purpose, but also in accordance with the specification. And that would also be taken into consideration by using good industry practice. And this clause has to be read in conjunction with a clause that was added in the technical requirements document, which when you read it, it is very clear in that it says the detailed design of the foundation structure shall be according to the method of design by direct simulation of the combined load effects of simultaneous load processes, and it references this code. So while that might be a bit of gobbledygook to your average layperson, essentially the detailed design of the foundation had to comply with DNV OS J101. And then as you read on in the second paragraph, it also states that the design shall be optimized using an integrated foundation, transition piece, a tower model, which are all your main components, of course, but the design of the foundations shall ensure a lifetime of 20 years in every aspect. And the important issue to consider here is the foundations were certified by DNV as compliant with DNV's code J101. So just to summarize, the contractor had to comply with fitness for purpose. The plant had to be designed and made in accordance with the specification, utilizing good industry practice. And the contractor had to comply with the J101 code, which was certified by DNV. Now, unfortunately, DNV contacted the market in September of 2009 and said that there was an incorrect calculation within its J101 certification. And essentially what they had done was it overestimated the capacity in the grouted connection. And what that led to was a very high chance, or what had already been experienced on this wind farm, of the grouting failing and the TP falling down on the monopile. So E.ON, as the company or client, argued that the contractor had warranted that the foundation structures would have a service life of 20 years and that they had to be fit for purpose, which arguably they were not, in the fact that they were failing so soon after going live. Whereas the contractor argued that it had complied with the specification, it had complied with J101, which was proven by the certification given by DNV, so that they had complied with all of their obligations. Now, ultimately, this went all the way to the highest court of England, and the court concluded in company's favour, saying that it accepted that the contractor had complied with the specification, and it accepted that the contractor had relied upon the J101, which ultimately, unfortunately, was incorrect. However, it also had a higher obligation to ensure the lifetime of 20 years. And the extremely important point to take from this case, one is you can see the magnitude of the risk taken on by contractor in this project, but also the courts made it very clear, because contractor argued there was 900 pages in the contract. There were 12 exhibits attached to the main contract given by all of the relevant contractors who were going to provide components. And this term stating that the design of the foundation shall ensure a lifetime of 20 years was a 1 or 2 liner in page 750. And if it had really meant to mean what it said, it would have been put in the main contract or brought to the party's attention far more than it was, rather than being hidden in page 740 out of 900. And the court disagreed. The court came and said that both were commercial parties, and whether it's on page 899 or page 2 is irrelevant, and that the contractor was bound by exactly what they had entered into. So while that in itself is a big learning or a takeaway point, in that whatever the size contract you're entering into, and I go back to my earlier example of whether it's a 2-pager or it's a 900-pager, you are going to be bound by the terms you've agreed to that. And the courts are very reluctant to ever come away from that, or to give you leniency into what you've agreed to. And the second point is, in this case, contractor had agreed to make the plant or the works fit for purpose. And while fitness for purpose, it will say at the time it was installed, it was fit for purpose. The courts found that it had to go to the higher standard, which was the 20 years. So you can see the obligations undertaken by contractor in this case were extremely high. And unfortunately, contractor had to pick up the bill of 26 million.
Yeah, so this case is another example of the point I made earlier, that quite often where there's dispute and there's uncertainty in the contract as to the as to the standard of performance of the contractor. It's the contractor that tends to lose out and be told that for his or her lump sum, what they need to deliver really is something which works as had been anticipated. It's quite difficult for contractor to rely or to succeed in an argument that, in fact, even though the deliverable doesn't work as anticipated, that the contractor has nevertheless performed his contract and is not liable for that.
And you may have come across the announcement that was made public yesterday on the offshore wind farm in the North Sea of Germany, in Merkur, which only went live in 2019, but has already identified that there's stress failures in some of the turbines. So a massive investigation is currently commencing there, but we presume that the exact same arguments are going to be raised by employer and potentially by contractor, depending on the contractual wording. But there is a very high chance that that contract on that wind farm contains very similar terms to what was seen here in MT Hoggard. So the next issue we're going to deal with is obligations as to time, which unfortunately it gets a lot of airtime and is referenced throughout contracts, but unfortunately it's a very difficult issue generally to become comfortable with unless you understand all the implications of the timing issues throughout your contract. And essentially it's time is of the essence is the phrase, but when a time limit in a contract is an essential condition, breaching that condition may result in the loss of the right to terminate, or it may give the right to terminate, excuse me. So the implications can be considerable, and generally this is referred to as time is of the essence. So essentially to reading a contract, if you see a contractual deadline, even a slight deviation past that deadline may give the innocent party to the contract a right to terminate and seek all of its damages, which have been as a result of you not complying with your contractual obligations to meet that time. And time is of the essence is extremely draconian nature, because the consequence of being late is irrelevant. So whether you are a minute late or 9 days late, it still gives the innocent party the same rights. And this again is a very vivid example provided by the English courts of in 1997. The parties entered into a sale contract of a very nice apartment in Hong Kong, but the contract clearly stated that if the acceptance hadn't been received by 5 p.m. on the 29th of September, that the seller had the right to hold the deposit and terminate the contract. Now, due to traffic issues, the courier arrived at the seller's location 10 minutes after the deadline, to which the seller notified the courier that he had terminated the contract and was withholding the deposit and therefore not actually accepting the purchaser's acceptance. This went to court, and the courts ultimately concluded in the seller's favor, because the terms of the contract made it very clear that time was of the essence and the deadline was missed, therefore giving the seller the opportunity and the right to terminate the contract and withhold the deposit. And as you can see on the left of the slide, we've included some example clauses which may, on assessment of the entire contract, may conclude that time is of the essence within your contract, and some of the terms which would be increasingly difficult to find that time was of the essence. So by 5 p.m. on the 30th of April, it is an absolute obligation. And therefore, if you miss that deadline, the innocent party is entitled to, at a minimum, claim damages from the breach of the contract, but potentially argue that time is of the essence in that contract. Again, on or before the 1st of May is a definitive time and an absolute obligation. Whereas within a reasonable time after signing this contract, that is no absolute obligation. A reasonable time can be assessed from a number of circumstances, and will have to take into consideration all the information available in relevance to that contract and that project. Whereas within 3 months after delivery of the goods is, again, an absolute obligation. It's a definitive time, and therefore would lead one to either be in breach of just a timing obligation, or potentially be argued that time was of the essence in that contract.
Yeah, it would be a brave recipient of goods or services to say that a party is in breach of a reasonable time type obligation, and therefore that receiving party has a right to terminate. That would be brave. And obviously, if you seek to terminate a contract because you say the other party has performed too late, you run the risk of repudiating the contract yourself if in fact you're wrong about that and the right to terminate hasn't arisen. So there is risk always in terminating contracts, and this time of the essence wording is often bandied around. It's used in contracts, and sometimes it does have this effect of rendering the time for performance as a condition, where even a minor breach entitles termination. But sometimes it's used in a contract, and the courts will find that it doesn't have that effect. It's quite commonly used, but where it is used, it's not necessarily effective. So if the court will always look at the intention of the parties, they'll read the entire contract, and if on analysis they find that time really isn't of the essence of this contract, they won't give effect to those words. But they can have, the purpose of this slide is they can have an effect which is perhaps not immediately recognised by parties using this sort of wording.
And for that reason, as Tom said, it's being bandied around in contracts and being used or even somewhat misused in some contracts. We thought it was quite important just to consider from the party side what happens if I am late. There is a definite time put in a contract. Unfortunately, for whatever reason you don't meet that, you need to be asking yourselves, well, what is my liability? And the first one is, of course, termination. If the contract is subject to a time is of the essence obligation and the timing is missed, the innocent party has a right to terminate. However, what we normally see, due to the uncertainty surrounding whether or not time was of the essence, taking into consideration all the clauses in the contract, normally the parties will rely on an express obligation, an express right, that allows them or permits them to terminate the contract if, let's say, contractor is 15 days late. So the employer, the end client, can rely on that clause without the uncertainty of arguing whether or not it is time is of the essence. And our main issue to why we wanted to flag this is because it's a very uncertain area. And if you are even considering terminating a contract, it's extremely important that you do seek independent legal advice, because if you terminate relying on the ground that the contract was subject to times of the essence and you were late in the provision of your works, but you are found to be wrong and the contract wasn't actually times of the essence, or that specific obligation wasn't, you will be in repudiatory breach of your contract because you sought to terminate that contract unlawfully. So it is an extremely high risk scenario and can have serious consequences for both parties involved if one of who was originally the innocent party seeks to terminate, incorrectly interpreting its rights under the contract.
Yeah, and I'd add to that we'd encourage you to seek legal advice, even if you're relying on a contractual right to terminate after a defined period, say. And the reason I say that is because where under general law you don't have a right to terminate, but you're just following a contractual mechanism that allows you to do so, if you don't follow that to the letter, then again you terminate improperly and you run the risk of them being liable yourself. So termination is a significant thing, and so yeah, we'd encourage legal advice is taken before you press the button. And
that then goes on to damages. So as I said, if there is a time in your contract for the provision of services or the completion of works, and you miss that, there will be damages claimable from you by the innocent party, and they're the damages that they've incurred due to your breach of that absolute obligation to meet that timing. And then essentially the overarching question is how do I protect myself from this? And realistically, the best way we see ourselves being able to negotiate this issue is including liquidated damages clauses. So by actually including a liquidated damages clause, you've actually reduced the possibility of the innocent party arguing that time was of the essence, because what you'll be saying is, well, we always predicted I could have been late because we've inserted this liquidated damages clause. So if time was of the essence, I never would have included that, because you would have had the right at least to terminate the contract. But including liquidated damages gives the contractor essentially a seat at the negotiating table to actually determine its liabilities. And that's always a very heavily negotiated clause, is how much liquidated damages are going to be applicable per day, per month, and when they cap out. So essentially, we see this as a great way to protect oneself in any contract, is agreeing to liquidated damages, which the contractor is comfortable with, completely appreciating that he or she may have to actually ultimately pay them. But the issue we see frequently is that contractors are reluctant to agree to liquidated damages. But from a legal perspective, we see it actually as a great way to protect oneself. And to actually be able to predict your maximum liability, because that will be most likely the clients and the employer's only remedy against you if you are late. So it's an easily calculable, predictable number that you're going to have to pay. So therefore, if you are late, you don't receive a long letter with schedules attached claiming X, Y, Z, A, B, C's and hundreds of thousands of sums in it. You just receive a letter saying you're late and here's the calculation on the LDs.
Yeah. So where your delivery of a component, say, means that an offshore head contractor misses an offshore season, say, and therefore the project goes back an entire season, then the losses could be large. And it may be that your deliverable in terms of value is small. But you run the risk then of being liable for all the losses that flow from your breach of contract, your late delivery. So from that point of view, a liquidated damages clause that caps your liability for delay is the sole remedy of the employer for delay, operates in the favour of contractor. And what as Cathal says, what we see is that contractors see it as they're giving something away. They're promising to pay an amount of money in circumstances of delay, and they're reticent to volunteer that. But that's because they're seeing it as a remedy that they're giving to the other side, rather than as a contractual protection, which is, we say, is the proper way to view it. From the employer side, there's a benefit in the sense that it doesn't need to demonstrate its loss. So even if in fact the contractor is late and the employer doesn't suffer any loss, in reality, it's still entitled to recover liquidated damages, essentially as a debt, regardless of that fact. So there is a potential benefit for the employer as well.
And then we come on to our conclusions. So appreciating the range of members dialed in, we separated this into contractor and employer. So if you are the contractor and you are entering into any size or value contract, we advise that you must be clear on what you actually have to undertake in order to discharge your contractual duties. And while I say that, excuse me, and it sounds perfectly clear, and you're probably saying, Carl, teach me something I don't know, we can't overemphasize just how often this is actually skipped or not just done correctly, and ultimately leads to the contractor incurring considerable costs, or at least a dispute arising because the contractor and or the employer were just not clear on the contractual duties that the parties had thought they agreed to. Excuse me. It assists if you have a very clear and delimited scope of work, so you know what you have to do and what definitely you don't have to do. And working to a detailed specification rather than working to a functional one will assist a contractor in staying away from our fitness for purpose arguments, which we discussed earlier today.
So 1, 2, and 3 there are essentially the same point. That's where contractor wants to be. Obviously, from an employer perspective, that's not really what they want. They want to know that after they've had this contract signed and agreed a price and paid the price, that they get what they bargained for. So this is where there's always a negotiation to be had. And we've a client who says, well, I quite like having grey in my contracts because it enables me to reach a deal. And all right, I recognise the fact that at some point I may have to have a debate about whether I'm obliged to do something as part of that contract, or whether that's an extra that I can recover under a variation or a change. But I'm prepared to accept that risk just to get the deal done. And so as lawyers, we obviously recognise that there is that element to this. But for simplicity and for certainty, the contractor prefers usually to know precisely what it needs to deliver. And once it's delivered it, regardless then of the outcome for the employer, that the contractor has satisfied its obligation.
And to avoid issues down the line, the client should be asked to warrant the accuracy of its design, however preliminary. And as we said earlier, that's going to be rarely given, but as I would say, if you don't ask, you don't get, at least for the negotiation purposes. And then the contractor should never overestimate giving itself sufficient time for design verification. And we've been involved in a number of disputes where the design was far more youthful or immature than contractor had actually thought, and therefore finds itself already against the clock, especially if it is an offshore project where there is a weather window which has to be met and makes everything far more difficult and costly if it goes wrong. But make sure that you're not late from the very start and that you understand what you are ultimately going to be making. And then point 6 is fitness for purpose warranty should be avoided if possible for all of the reasons discussed earlier today. But if the client is insisting that fitness for purpose is included, which normally it will for an EPC contract, you have to go back to point 1 and just be extremely clear on what you will actually have to undertake. And using my railway case as a prime example of wording that can ultimately come back to be extremely costly. Number 7 is understand your obligations as to time. Appreciating what you've agreed to on the day of signing is one thing, but actually understanding that as your project develops, especially if you're on a multi-seasonal project, understanding your obligations as to time is extremely important. And identifying what are your ramifications of delay and are they dealt for accordingly within the contract, like we discussed, for example, liquidated damages. And ensure, therefore, your contractual protections are included. Liquidated damages, being very clear on clients' rights for termination. You know, it just gives certainty to the contractor, and both parties are going into the contract with its eyes open.
Yeah, and with regard to the what, so the condition of your deliverable, the contractual protection in the contract you're most likely to seek to rely on there, where in fact there are defects found in what you've delivered, is sort of a defects correction type clause. And again, sometimes that's considered to be a remedy that you're giving to employer or client as a contractor. But again, if it's properly drafted, what that clause should do is say that remedy that you're giving, your promise to rectify the defect, is the sole liability, and that the promises you make in that sometimes called a guarantee clause, the guarantee you're giving, in other words, that perhaps the deliverable will be free from defects for a period of time, a year, 24 months, say. That's the only promise you give as to the condition, and that's in place of any implied warranty or condition from statute or anything, that everything is within that guarantee clause. You promise it will be free of defects. If it's not, you're correct. and that's it. That's the sole liability. And again, that operates as a protection for contractor. But again, as an employer, you might welcome that because you know there's a contractual mechanism in place, perhaps backed by some sort of performance bond, which you can call on in the event that a defect is discovered.
And then we'll look at from an employer's perspective. So the main issues that the employer will be trying to transfer onto the contractor is risk of errors in any company provided design, again, however immature or youthful, are for contractor.
Yeah, the company will say, well, look, we've commissioned this feed or pre-feed or whatever it might be. We're handing it over to you. You contractor, you're the experts. Review it, verify it, and then it's up to you to develop that immature design and deliver a finished product. And we're not taking any risk for errors in that basic design, should we say, because it's in the nature of a basic design that it needs improvement and development. So that the employer would seek to transfer that to contractor.
And then, as we've talked throughout our talk, making sure that it's a functional specification and fit for purpose will mitigate a lot of employers' risk. And then last but not least is risk of delay, how employer wants to deal with that. Again, depending on what actually the product or the work scope is, you'll have different variances on what you can accept on delay depending on the contract, and tailoring that to make sure that it all cumulatively is correct for installation offshore is very important, and something to be considered in a wider scope when you've got several contractors or several stages of the build. Delay in the offshore sector is a major issue which can cause considerable costs for both parties.
Yeah. The considerations are different. So in oil and gas, for example, a contractor might say to the employer, well, what does it matter that we've delayed you an offshore season because the oil or the gas is still in the ground? So you can profit from that next year. It hasn't gone anywhere. Whereas obviously the profile with delay is a bit different, where we're talking about income streams from a revenue earning asset in wave or tidal. And
then last but not least, we've got just a summary essentially, but appreciating, Jay, that there is 1 minute and a half left. I'm just going to check the chat just to see if there is anything there. There is. David, are there any laws or knowledge unique to Wales to consider for projects?
Local regulatory, I suppose.
Yeah, David, just reading your question, not that we know of, but that, yeah, Tom is referring to local regulations for specific offshore projects, which be given really in the consent stages. Yeah, but from a project contracting perspective between employer, contractor, subcontractor, there should be no difference whatsoever between projects England, Wales, and without being held to it. Very similar concepts that we've discussed today will be applicable in Irish contracts as well. But last but not least is the risk matrix, and essentially this is just to summarize. Ignoring the risk very rarely works as a successful strategy, but that simply goes back to just reading the contract. And as wave and tidal projects get bigger and more complicated, reading the contract but actually having a contract management system in place is extremely beneficial. We've been involved with a number of disputes which have simply come down to contract management failures, be that notices, updates. They can unfortunately cause considerable issues in the contract. Avoiding delay that's simply to be undertaken in your negotiations, narrowing the scope or becoming very clear on the scope depending on who you are, can avoid a lot of risk. And then of course you can accept the risk, but pricing that in accordingly is very important. And unfortunately, in such a competitive process with the small number of projects that are currently underway, that employers in a very favorable position. Reducing risk, again, it just to be taken into account when you're negotiating contracts, to make sure that you've some protectionism in place through any of the measures that we talked about today. And then, of course, we could transfer risk, and that's getting applicable insurances in place. And as I said earlier, if you agreed for fitness for purpose, it is very difficult to get insurance to cover that. However, we understand that on larger scale projects, that bespoke insurance policies are obtainable, and we recommend, well, one, being in good communication with your broker throughout the life cycle, because as the projects get bigger, these bespoke products become more available. And then exploit essentially is for the employer, given it is such a competitive market, getting clauses included in contracts which are non-negotiable from the employer's perspective, it is frequently seen.
Thank you very much there, guys. That was really informative. I think the fact that we didn't have many questions come in shows that you did a good job at breaking this down for all of us lay people that aren't so versed in legal matters. Oh, great, you've got your contact details there. I was just going to suggest that you pop them up for the benefit of everybody in the chat. So hopefully they can follow up with you now if they do have any questions they'd like to get back to you on. We've just had a comment come in from Manuel. Maybe we can address that before closing up. I am conscious that some people are dropping off now as we've passed the hours. They may have other commitments and meetings. But maybe if we can address Manuel's comment, and then if anybody else has any questions, please feel free to get in touch with either Cathal or Tom. Yeah, they've had a really informative session there, which has really helped break down what would otherwise be quite the dry world of legal for the rest of us.
You mean our day job, Jay?
Well, for us, it's a little bit tricky, you know, like us who aren't engaged with it. But yeah, you've done a good job there explaining it for all of us. Yeah.
Manuel, this is a question we're seeing raised increasingly as these new markets emerge. And we were recently involved with one out of our Singapore office. But essentially, a lot of the parties are still agreeing to English and Welsh jurisdictional clauses in their contracts, which are very well known to the main, your tier one contractors and a number of your employers, just for the predictability that the English courts give. It doesn't get around all of the situations you're going to potentially encounter, but we're involved with projects all over the world, you know, which even from the oil and gas perspective still rely just on English law to try and give them some certainty and predictability in their contracting structure. Granted, you have to go through the English courts, but that's not really a major issue, considering the provision of services is so readily available in, let's take a Taiwan with you know, either sister firms or with best friend relationships between the law firms.
Cool.
The only thing I'd add is, sometimes it surprises people to learn how readily in China, for example, you can enforce English arbitration awards, for example. So the Chinese courts take seriously English arbitration awards and their obligations under the New York Convention, and so we've had some great successes enforcing English arbitration awards against Chinese companies even. Not every time, obviously, but that is an approach that's available and a route that's commonly used. But obviously, you do come up against counterparties who just say, I'm not going to work on anything other than local law, and in that situation, it is just a negotiating position type issue. If you can't force them to change their minds, then you take the legal risk of being in an unfamiliar jurisdiction with perhaps a less experienced judiciary deciding your disputes. Yeah, that's something we're very familiar with as a problem.
Yeah, Manuel, it's one where there's a lot of background information, but please do get in touch if you'd like us to discuss it over a Zoom or a Teams, because it is something that we're coming across increasingly as we see European contractors travel further afield, but also as local companies are entering into contracts where the contractor is demanding English jurisdiction. But the local company, local employer, local client wants the local law, of course.
Now, I've got one at the moment where we've sort of negotiated a hybrid type position where the employer wants a Romanian governing law, which our client doesn't feel it can negotiate its way out of that, but it said it wants its disputes heard in London, in an arbitration in London. So we've got London arbitration, but applying Romanian law principles. So that sort of hybrid scheme is also a possible way of resolving that difficulty, that conflict.
Excellent, Jay. That looks like
that looks like all the questions. Yeah, again, thanks again to you two for joining us and spending your time with us today. I'd encourage everybody in our audience to reach out to Tom and Cathal at Stephenson Harwood if you have any questions or you need legal services to assist you with your projects moving forward. Those of you in our audience, you're more than welcome to sign up to the Selkie newsletter to find out a bit more. There should be a link in the chat. You can also join our Selkie network discussion group, where we will be facilitating discussions and conversations about entering the industry. And there's also a link there to the rest of the events in this series. So the Meet the Expert event series is all about providing business support to those who are entering the industry, covering a range of topics. Today we covered legal. We have a bunch of other ones coming up regularly all the way through to September. You can find out more information on the link there. So I'll just extend a thanks once more to our speakers for today's presentation, and I hope everybody enjoys the rest of your day and the rest of your week. Bye.
Thanks, Jay.
Thanks, everyone. Thanks, Jay.
Thank you.